The government proposes to abolish the right to trial by jury for a vast range of offences. Any case where they expect a sentence of 3 years or less. This is nothing less than wielding a constitutional axe against the centuries-old cornerstone of our liberty. Juries are not some bureaucratic add-on to our justice system. Juries are the means by which the public consents to and participates in the exercise of the gravest power of the state, the power to convict and to imprison our fellow citizens. Yes, we face a serious Crown Court backlog. That is not in any dispute today. That is not even a subject of today's debate, because everyone on both sides of the House know it and acknowledge it. We all accept that the roots of it did not begin under this Labour government. It goes back to the pandemic. It goes back further than that. We all accept that there has been a lack of investment in our criminal justice system under governments of all political persuasions, that the criminal bar is in a weak place, that young people don't feel that they can go into the law, or at least not into this most challenging and poorly paid part of it. We all accept that some of our courtrooms are in a terrible state today, that the IT system is failing, that the contracts for getting prisoners to court on time are poorly managed, and the private contractors underperforming. We all accept that this system is in a mess and needs to be reformed. But that is not the question at hand today. The question before us now is, what is the best way to resolve this, and is the route to fix our criminal justice system and to deliver swift justice for victims to scrap something that we have known as a country since 1215, if not before? I'll happily give way.
Chair the Minister for giving way. He's always very generous with his time. He talks about the length of time it takes for victims to get justice. I speak to police officers in my constituency of Harlow all the time and say one of the issues is with this backlog, this waiting list, is the fact that you've actually got police officers who've been police officers for 3 years who are asked to go to court who, for cases, for things that happened before they're even police officers. Does he recognise this? That's a huge challenge and one that we need to overcome.
I do. The Honourable Gentleman is absolutely right. Look, it is shameful to our country that there are victims of serious crime, like rape, who are waiting until 2028, 2029. In fact, I believe the longest listing hence is 2030 today. No one in this chamber could possibly defend that for one moment. But will this make a material difference to fixing that problem? No. Well, I don't believe it will. I've not heard anyone make the case that it really, in their hearts, will fix this problem. And I'll give way in one moment. And if it is going to make a difference, publish the modelling, the evidence, so we can see it. Because Lord Leveson hasn't published any modelling. Lord Leveson gave a view that it might lead to a 20% reduction in the length of a trial, heavily disputed by other practitioners, including, and I do not mean to demean Lord Leveson, but including from people who are closer to the coalface of our criminal justice system, judges and criminal barristers. The department has not published any modelling. Does it exist? If it does, publish it, and then we can have an honest and evidence-led debate. I'll give way to my right honourable friend.
As my right honourable friend squares up to lead civil society in a battle against this monstrous measure, can I ask him to have some sympathy for members opposite, who are about to be led to the top of the hill once again, as they were with the farm tax, as they were with the winter fuel allowance, on a measure that simply will not deliver the solution it's designed to, and they'll all end up having the rug ripped from under them once again after enduring all the political pain.
Well, my right honourable friend is right, and having served as a minister in the last Conservative government under multiple prime ministers, I've been led up a few hills before myself, and I know what it feels like to be a minister in this situation. This is not a hill to die upon. Let's fix this problem. Let's build a cross-party consensus on how we get the backlog down, and I'll speak about a few of the solutions as I see them, as we see them in a moment. This policy is not going to happen. I honestly believe this is not going to happen. There is opposition, not from the official opposition, but from every other party, from Reform, from Plaid, from Independents, from the Liberal Democrats. There's opposition from members of the Labour Party, good, experienced colleagues on the other side. There's opposition in the House of Lords from Labour peers of the highest repute, like Helena Kennedy, people who have spent careers in the law. This was not in a manifesto. The House of Lords does not have to support this. The last time Jack Straw and Tony Blair tried to do this, the House of Lords stepped in and it failed. This is a distraction. This is a waste of everyone's time. If the Deputy Prime Minister and the Justice Secretary and his ministers care about swift justice, scrap this pointless distraction and focus every hour of the day on the hard yards of government, of doing the difficult things, the administrative failures of the Ministry of Justice that have existed for years, so we can actually ensure that the backlog is brought down. I'll come to the Honourable Lady in one moment, but I'll give way to my right honourable friend.
My right honourable friend is being characteristically over-generous to the government when he talks about requiring their modelling. This is not a mastermind question. This is simple arithmetic. 3% of the trials. Right? Let's say we do away with half of them, which is more draconian, I think, than even they're talking about, and a 20% difference. The maximum difference that can make to the throughput of the court system is 0.3%. It will make no difference whatsoever to one of our most fundamental issues here, and yet it will actually throw away our most fundamental tenet of our justice system.
Well, my right honourable friend is absolutely right. And this is why, if the government has a case, publish the evidence.
Help a little bit.
Publish the modelling.
Sorry. It's easy if you look to me because I can't pick it up all the time when you turn the other way. Thank you.
Of course, Mr. Speaker, apologies. Publish the evidence. Publish the modelling. This isn't a minor policy. This is changing something that we have enjoyed as a country for hundreds of years. To do something as significant as this should be done on the basis of evidence. So I would urge the Minister today, whether they accept our motion or not, is by the by, but accept the spirit of it and publish the evidence now so that everyone can see it. The lawyers, the judges, the practitioners who care and are worried about this can then engage in a proper debate. And above all, we in the House of Commons, who are the guardians of our Constitution and our ancient liberties, can have a debate on the basis of facts. If the Honourable Lady would give way, then I'll give way to the Honourable
Lawrence. I thank the right honourable member for giving way, and I think he has made some very valid points in terms of the situation we are now faced. The fact that we see over 78,000 cases and caught up in that backlog, many of our constituents waiting for their day for justice. That justice denied, we know many people cannot continue to wait that way. But does he accept that all the issues that he's outlined now is something that there was not enough focus on during the last administration, and they could have done a lot more to resolve this, so we are now not in this difficult situation where we are having to find a way to address this?
I think both parties must share in the blame for the present situation. Look, the permanent secretary, or the former permanent secretary of the Ministry of Justice, came before the Justice Select Committee last year and was asked, broadly speaking, the question that you have just asked me. The Honourable Lady has just asked me. What is the root cause of the current backlog? And she responded that although the poor funding for the system had existed for some time and that had created a number of challenges, the primary cause was the pandemic. That COVID created immense strain on our criminal justice system. And as a result of that, a backlog that had, broadly speaking, been falling in the years prior to it, it had begun to rise slightly in the immediate period before the pandemic, but had, broadly speaking, been falling in the years beforehand, then shot up. Then, the Ministry of Justice...
I'm not having both sides cross-examining each other. I'm listening to just one person at the moment.
I'm just restating, I think fairly, what the Permanent Secretary said. Then, the Ministry of Justice did not do enough to get the backlog under control. There has been a serious failure to fix the productivity problems in our court system, as I think the IFS set out in a report last year, independently. Could the last government have done more? Well, perhaps it could have done. It did try to do things. It increased sitting days. It brought in the special courts so that there could be courts being held like Nightingale courts in parts of the country. And this began to make some difference. But the backlog kept rising nonetheless. The backlog has risen very substantially under this Labour government as well. In fact, to the extent we have accurate figures, it's rising by about 500 cases every month. So the problem has continued to get worse and worse. I don't therefore see today's debate as a partisan debate between the two parties. The key thing here is, how do we solve the problem now?
Absolutely.
How do we look to the future? Is slashing jury trials the answer? No. Are there better ways to do this? Yes. I'll give way to the honourable gentleman.
Grateful to the right honourable gentleman for giving way. It pains me, I have to tell you, Mr Speaker, to say that I agree with the very vast majority of what he's saying from the dispatch box. He referred to Sir Brian Levison. None of us would suggest that Sir Brian doesn't know what he's doing, of course. He's very eminent. He is very skillful. He's taken a great deal of time to come up with his suggestions. But does the honourable gentleman know of any situation before when the Bar Council, the Criminal Bar Association, circuit leaders and every other stakeholder in the criminal justice system have been at one in opposition to what is an utterly ludicrous, unworkable policy?
Well, I rest my case, my lord. I thank the honourable gentleman sincerely for the way he has conducted himself and the campaign that he has and is fighting on this issue, because I know it's not easy to do so, having been someone who has campaigned at times against my own government, voted against the last Conservative government. I credit him for the work that he's doing. But let me answer the honourable gentleman's point, because he is making an important point here. Lawyers rarely agree. In fact, their profession is often to disagree. This has united everyone in opposition. The Law Society, the Bar Council, the Criminal Bar Association, lawyer after lawyer after lawyer have been saying that this policy is wrong, a better way is possible. And this isn't party political. It cuts across all sides. Yeah. You know, there are people who have been vehement critics of myself. You know, I woke up the other day to hear Anna Soubry on the Today programme saying that everything that I was arguing was right. This is not about party politics. This is about getting the right answer for our criminal justice system.
I'm very grateful to my right honourable friend. Would you agree that there are alternative models to get to the place that we all want to be at, that is to say, reducing this awful backlog that is denying justice to people? And would he take particular note, I'm sure he probably has already, of the model introduced by my constituent James Ward OBE in the South West, which had COVID resolution courts that were able to bring through proper case management within the CPS the backlog down from 52% to 2%, which meant saving 10 sitting years as a result of that intervention alone.
Well, Jenrick, my honourable friend is absolutely right, and let me come to some of the potential solutions. One of the points that is important to note is that the backlog varies very widely across the country. HMCTS is a poorly managed organisation with limited accountability to ministers and has not been performing its function as well as it should do. There are parts of our country where the backlog is far lower than others. If you go to Liverpool, for example, parts of Lancashire, Mr. Speaker, you will see that despite the closure of your local court, the court backlog is substantially lower. In Wales, the court backlog is substantially lower. So there are significant regional differences as better managers active judges, good case management of the kind that my honourable friend mentioned has made a significant difference. If I just advance my case a little bit, now I'll come to my honourable friend. The most important thing that we could do now is to get the courts sitting round the clock. Yeah. There are sitting days on the table which are not being used. The Lady Chief Justice, the most senior person in our judiciary, has said repeatedly that she is able to offer the government more sitting days. She said it in the press, she said it before the Justice Select Committee the other day, and I'm sure she said it privately to ministers as well. The government has been pushed slowly to take her up on those sitting days, and I commend them for that. But there are still, by her measure, I'll give way in a moment, there are still, by her measure, at least 2,000 extra sitting days available, which the government is not taking her up on. We need to go back to the Lady Chief Justice and welcome these sitting days with open arms and say, what would it take for you to produce more? Can we turn 2,000 to 5,000 to 10,000? Get the courts actually sitting. That is not happening right now. And the principal reason for it is financial. Because the Ministry of Justice has not been able to secure from the Treasury a comparatively small sum of money. We can argue about the priorities of this government and we will differ across the House. But this is a relatively small sum of money which we need for the proper operation of our criminal justice system. And it must be better to spend this money on this cause than to scrap an ancient freedom that we have enjoyed for generation after generation. I'll give way to the Honourable Lady.
Thank you very much, Mr. Speaker. I'm really grateful to my right honourable friend for giving way. He's making some excellent points about some of the alternative solutions to scrapping the right to a jury trial. And any MP who spent any time in their local courts will have seen that actually the issue isn't with juries, it's with the poor administration that's resulting in about a quarter of trials having to be rescheduled. So I wonder if he agrees with me that actually, rather than setting this precedent of scrapping the right to trial by jury, the government should maybe start by looking at ways they could removing the pressure on an overwhelmed CPS. And does he think that maybe the possibility of giving the police greater charging powers would be a way to move forward on this?
Jenrick. My honourable friend makes a number of very important points. Look, there are better ways to handle this situation. I don't pretend they're simple. They're difficult. They involve getting to the heart of bureaucratic organisations that have been poorly managed and are unaccountable. But let's look at some of those solutions. One, which Brian Levison himself mentions in his report, is incentivising early pleas to prevent cases dragging on unnecessarily. For example, by ensuring that those who are accused of offences meet their counsel earlier in the process, so they can have good advice about their likelihood of success or otherwise sooner than they do today, and changing the fee structure accordingly to achieve that. We'll give way on that point, yeah.
Jim Shannon. I thank the right honourable member and the Shadow Minister for bringing this forward. In Northern Ireland, just to give an example of perhaps maybe when the Shadow Minister is looking at some of the options, we have had cause to use the duplicate courts on many occasions, and in 2023 it was only used in 0.8% of occasions because terrorist trials and serious criminal trials are not given the opportunity because of intimidation. But our natural sense of justice demands a jury of our peers, and does the right honourable member agree with that? And does he also agree that jury trials must remain exceptional and justice can be served more efficiently by juries by increasing court dates and cutting down the number of ineffective trials that waste time, the very thing that the right honourable member has referred to?
Well, my honourable friend is making a series of very important points. There's something very special about being judged by a group of your own peers, the wisdom of ordinary members of the public coming together. It is basically the only opportunity for members of the public to participate in our criminal justice system. And that's something that's very important and which should be preserved. He's right to say we need to get the court sitting round the clock. Just this week alone, because of closed courtrooms, 241 sitting days have been missed. 241 in 3 days. Imagine what that is over the course of a year. We need to ensure that prisoners are arriving at court on time. The present contract is not working properly. That leads to too many trials to collapse or to suffer unacceptable levels of delay. We need to drastically improve court IT, ending the technical failures that waste hours of court time every week. As I said earlier, we need to provide proper support for the criminal bar, and I welcome the modest intervention that was made by the Justice Secretary in that respect the other day, ensuring there are enough advocates to prosecute and defend cases. These are the bottlenecks that actually drive delays. The bottleneck is a problem of resources and management, not an inevitable side effect of having citizens weigh evidence. Jury trials are not the problem. We've got to ensure that we actually get to the root of the challenge, not get rid of something that we've enjoyed for such a long period of time. Let me just mention the degree of opposition that there is right now, as my honourable friend rightly mentioned, because it is important to note how broad the opposition is within the legal world, for whom alarm bells are ringing over this proposal. The Law Society, representing thousands of solicitors, calls it an extreme measure that goes too far and fundamentally changes how our criminal justice system operates. Its president, Mark Evans, warned that the plan actually goes further than the recommendations of Sir Brian Levison's review of efficiency and isn't backed by evidence that it will solve the backlog. The Bar Council, representing barristers, have been equally clear. They see no basis for altering the structure of the court system in this way, warning that limiting the right to jury trial strikes at a core citizen's right. I will give way, and then I must conclude my remarks, because there's clearly a lot of colleagues who'd like to speak.
Ready? I'm obliged. Thank you very much, Mr. Speaker. Well, I just wonder if the Right Honourable Gentleman, the Shadow Secretary of State, could clarify just one point on the opposition's position. In Scotland, you've never had a right to elect for a jury trial as an accused. The position is the prosecution decides whether a case is to go for jury trial, and the accused has no right to require a jury trial. Is the opposition's position that such a reform in Britain, in England, should be opposed? That specific point about the election. Nothing.
Well, that is the subject of this debate, isn't it? England and Wales have their own legal tradition. Scotland has its. Those of us who represent constituencies in England and Wales are here to defend our constitutional rights and settlement, and we will do so. It's up to those in Scotland to choose their path forwards. But the honourable gentleman's question also begs another one. It begs an important question in this. Is this debate about a technical, bureaucratic one? How do we get the backlog down in the most expeditious way? Or does the honourable gentleman speak to an ideological view that jury trials are wrong or superfluous, that ordinary people don't know what they're talking about, their views should be casually set aside? I don't know the answer to that question with respect to the honourable gentleman, but there are some in our politics who do take that view. There are some who think that ordinary citizens cannot be trusted. As Baroness Helena Kennedy said, there had been a trope amongst some within the Labour tradition that had she assigned some of the view that had led to Tony Blair and Jack Straw taking the original decision. Now, that is clearly not all within the Labour tradition as we see today. It may be a very small minority. It's not one that we on this side support. We want to see ordinary people continue to be at the heart of our criminal justice system. And it's for that reason that we brought this motion today. So let me conclude by saying this. This is an Opposition Day debate. But the opposition to this proposal is not these green benches behind me. It's not the green benches to my left. It is all sides of the House and the other place. It's the solicitors, the barristers, the judges that can speak out, and those privately around their kitchen tables who can't. It is the ordinary citizens of our country who want to see this preserved. Poll after poll shows it clearly. This is 800 years of legal tradition. Let's not toss it aside. Let's defend it, because it matters. And then let's unite and find a way to fix the bureaucratic failures of the Ministry of Justice, to ensure, I can't give way at this one, ensure that we have swift justice. Justice delayed is justice denied. We all agree on that. We can do this without ruining a gift that this country has given to the Western world. A gift to the world, a fundamental part of our Constitution and our democracy. Vote for our motion today. Defend jury trials. And then tomorrow, let's work together to fix the court backlog. Yeah.